Hello everyone, my name is Curtis. Today I want to talk to you about the move-in affordability plan that went into effect on December 2nd, 2025. The move-in affordability plan is broken down into two bills. So the first bill focuses on rental applications and it provides information about background checks, credit checks, and fees, while the second bill focuses on security deposits. I'm going to give you all a quick breakdown of each bill, then after that I'm going to read the bills pretty much in full. So for the bill that focuses on rental applications, it is Bill 250045. Once again, that's Bill 250045. This bill limits the amount of fees that a landlord can charge an applicant within 1 year. When it comes to the background and or credit check, the landlord does have to get the applicant a copy of that. And then when it comes to an adverse action notice, which of course is when they either deny you or they say we're going to approve you, but it has some unfavorable terms, they do have to give a copy of that to the applicant. And then when it comes to the background and or credit check, when it comes to the cost that they can charge, it's pretty much going to be the lesser of $50 or the actual cost to run the checks. Now, when it comes to the bill that focuses on security deposits, the bill number is 250044-A. Once again, that's 250044-A. And this bill pretty much says that if the security deposit exceeds 1 month's rent, the landlord has to give the applicant the option to split the difference between the first month's rent and the rest of the deposit into 3 equal payments. And then also there is a provision that protects landlords that only own 1 to 2 rental units. All right, and so in this particular section, I am going to read the bills pretty much in full. And so I am going to start with the first bill, which again is 250045. This was signed on September 3rd, 2025. It was meant to go into effect 90 days after it was signed, which of course was December 2nd, 2025. The second bill follows that as well. There is a lot of information in the bill, so I am going to look directly at my notes, okay? So for the purpose of considering, assessing, or selecting one or more individuals for residential tenancy in a premises, no landlord, owner of a premises, real estate broker, real estate agent, person operating or managing a premises, or employee or agent thereof shall demand or accept any payment, fee, or charge from or on behalf of a prospective tenant other than a fee for conducting background check and or credit check subject to the limitation of this section. The following limitations shall apply with respect to the background and or credit check fees that may be charged to a prospective tenant as permitted by subsection 1. The total charge for any background check and or credit check shall not exceed the actual cost associated with conducting such checks or a total of $50, whichever is less. In no case shall any fee be charged for a background check or credit check that is not performed. No landlord or owner of a premises or employee or agent thereof shall charge a prospective tenant more than one fee in any 12-month period to conduct a background check and or credit check in association with applications for tenancy at any of the premises owned by the landlord or owner. In addition, no person operating or managing a premises or employee or agent thereof shall charge a prospective tenant more than one fee in any 12-month period to conduct a background check and or credit check in association with any application for tenancy at the same premises. Pay attention to the fact that it says that any of the premises owned by the landlord or owner. That is very important. Now, when it comes to the next part, it says a landlord, owner of a premises, real estate broker, real estate agent, person operating or managing a premises, or employer or agent thereof shall provide a copy of any background check and or credit check that is conducted as permitted by this section to individuals who are subject of the check. All credit checks and background checks carried out as permitted by this section shall also comply with requirements of the Fair Credit Reporting Act 15 U.S.C. 1681, including, if applicable, the requirements to provide a prospective tenant with an adverse action notice. And that is the end of the first bill. Once again, it is Bill 250045. It was signed on September 3rd, 2025, went into effect on December 2nd, 2025. All right, so let's get into the second bill, which is 250044-A. Once again, it was signed on September 3rd, 2025, went into effect on December 2nd, 2025. All right, so it says no owner, landlord, agent, or other persons operating or managing any premises shall charge or otherwise accept a security deposit that exceeds the amount permitted under 68 PS 250-511A. When an owner, landlord, agent, or other person operating or managing any premises charges a tenant up to 1 month's rent for the security deposit, the full security deposit may be collected as a lump sum. However, if the security deposit for the first month of tenancy shall exceed 1 month's rent, the owner, landlord, renter, or other persons operating by managing the premises shall, consistent with the tenant or prospective tenant's voice, accept payment for the security deposit either as a lump sum or two, in installments with 1 month's rent paid as a lump sum and the remaining paid in 3 equal payments due to no more regular than once a month, starting the month after the initiation of the tenancy. The total amount charged for a security deposit shall be the same, regardless of whether the security deposit is paid as a lump sum or in installments. So remember I was telling you all that there is something inside of the bill that pretty much protects landlords who only own 1 or 2 rental units? I'm going to talk about that right now. The provision of subsection B shall not apply to an owner, landlord, agent, or other person operating or managing 2 or fewer rental units. For purposes of this subsection, ownership interests shall be aggregated across all legal entities in which an individual or individuals have a direct or indirect ownership or control interest. Where multiple legal entities are used to hold title to separate properties, such properties shall be considered collectively for the purpose of this exemption if they are owned, operated, or managed substantially by the same individuals or entities. No owner, landlord, agent, or other person operating or managing any premises shall unlawfully retain any security deposit, however styled, in a lease. In an action before a court of competent jurisdiction, a person aggrieved by a violation of subsection 4, which is going into detail about the security deposits, shall be entitled to actual damages, or in the alternate, if the person aggrieved elects before judgment is rendered, statutory damages equivalent to the value of 1 month of rent. In addition, the court may award such person reasonable attorney's fees and costs. And once again, that is Bill 2500448. I do suggest that you all do go online and look at the bills yourselves. I did read them pretty much word for word, line by line, but I just feel like you need to see it yourself so that we can get the best understanding possible. And that is everything that I have. I do appreciate you all watching. If you could, please like, comment, share, subscribe. I would really appreciate it. I hope you all have a great rest of your day. You take care.